You are preparing for a jury trial, and you know that one of the things you have to do is get certain pieces of evidence admitted, right? Because just because you have a document doesn't make it admissible. In fact, just because you have a document doesn't mean the jury's ever going to see it. So how do you do that? How do you prepare for that? My name is Saul Gruber, and at Gruber Trial Consulting, we help lawyers all over the country get ready for trial and prepare for trial, whether it be by focus groups, rules, or simple things like a trial plan. And that's what we're going to talk about today. How are you going to get that document into evidence? And that document can be something as simple as a picture. It could be something as simple as a written statement. It could be sort of a police report or part of a medical record. But whatever it is, you want to get it into evidence. So the first thing we have to do is begin to prepare for that. Do we do that the night before trial, the week before trial? No, we do that in discovery. Because when you're in discovery and you're taking depositions, you're finding out what pieces of documents, what pieces of evidence are important, and you're beginning to lay the foundation. And foundation is a word that is used throughout the rules of evidence and certainly at trial. Was the proper foundation laid? In other words, if this is a document that is a part of a medical chart, was there a proper foundation saying it is accurate? It is an accurate representation of the chart? And is there something outside that within the hearsay rule, the exceptions of hearsay that will allow you to get that in? And you have to start planning that in discovery. Now, it's easy to show that a document is kept in an ordinary scope of business and course of business if you prepare for it. And how do you do that? Well, you take the deposition of the records clerk and you get them to answer certain questions, or you send them an affidavit when asking for the documents and have them say this is an accurate depiction of and reproduction of the records as kept in the ordinary course of business. So you kind of satisfy that, and there's really no reason when you get to trial for that to be an issue. If that's an issue, that means you really didn't do certain things that you should have done. And another way of doing that is a request for admissions, which we'll get to in a minute. So we're already okay with showing that it is what it purports to be, but that doesn't take care of all the hearsay objections, right? You have to be prepared for that. Don't start looking at the rules of evidence once there's an objection for the document going in saying it's hearsay, because pretty much everything that's within a document is going to be hearsay. It's just the nature of what hearsay is. So be prepared to know what the exceptions are, and in discovery, deal with those exceptions. If it's an admission against interest, deal with that during discovery. Do a request for admission for that. If you want to put a picture into evidence, then you want to deal with that it accurately reflects what it's supposed to look, the picture is supposed to look like at the time it was taken. Deal with that in request for admissions. Deal with that in discovery. What about the tougher ones? The ones where you're arguing, I don't know, present sense impression, or where you're going to argue that it was something that was told to a doctor in the ordinary course of treatment, so it was necessary. These are the things you need to deal with in discovery, no matter what they are. And it will take too long to go through all of these exceptions, but have a cheat sheet ready at the time of trial for every single document you choose to put into evidence. What do I mean by a cheat sheet? Is it hearsay? What is the exception? What is the things you have to show it comes under the exception? And is there any case law in your jurisdiction saying that? Most of the case law is going to be in your rules of evidence. Have it ready. So if there is an objection, you can hand to the court a memo on that piece of evidence immediately. There's nothing wrong with that. If you can't get the defense to agree beforehand and the request for admissions didn't work, have your cheat sheet ready. So what's our tip? When dealing with documentary evidence, make sure you deal with it in discovery, do requests for admissions, and have your cheat sheet ready for trial. That way, everything you want to go in evidence will go into evidence. If you like this video, please hit subscribe at the bottom so you can subscribe to our YouTube channel and get our weekly videos and get alerted to them. That way you don't miss anything. If you have any questions about getting things into evidence, please feel free to call us or email us. And don't forget to look at our podcast, The Jury Thinks What, where you can get with any podcasts on the Lawyer Minds ecosystem. And if you need any help, give us a call. We're here.